Hi everyone, welcome to Pimore Canada Immigration. I'm Zhang Hui, an RCSA and inactive Chinese lawyer. Last time, we explained the admissibility hearing. Today, we explain the detention review. The detention review is a legal proceeding held at the Immigration Division, the ID of the Immigration and Refugee Board, the IRB. This type of hearing is to decide whether the person detained, namely the detainee, should be continued detained. Both permanent residents and foreign nationals may be detained on prescribed legal grounds. PRs may be detained if an officer has reasonable grounds to believe that they are inadmissible and they are a danger to the public, or they are flight risk, which means likely they will not appear for examination, admissibility hearing, or removal, etc. In addition to these two grounds, foreign nationals may also be detained if the officer is not satisfied with their identity, i.e., the officer does not believe they say who they are. When seeking entry, PRs and foreign nationals may be detained if it is necessary to complete the examination, or an officer has reasonable grounds to suspect that they are inadmissible on the grounds of security, violating human or international rights, serious criminality, or organized criminality. The officer must notify the ID without delay when a person is detained. The ID needs to conduct the first detention review within 48 hours. If there are reasons for continued detention, the second detention review will be conducted within 7 days. If the continued detention is ordered by the ID member at the second detention review, then subsequent detention reviews will be conducted every 30 days. Please note, the detention review time limits for designated foreign national are different. Preparing a detention review hearing needs extensive immigration knowledge about the review proceedings and legal skills. If you are detained, you may be assisted by a duty counsel for free if you don't have a representative. Make sure you let the authority know if you need an interpreter, and ask the duty counsel or the representative retained by you any related questions to help you understand the situation you are in and the process of the proceedings. Though the onus is on the minister to establish the grounds for detention to seek release, detainees might as well present evidence to counter the grounds for detention. If the grounds for detention are not an issue, then detainees may propose the alternative to detention to the ID member. For example, posting a cash bond or a guarantor to dispel any concern the ID member may have for their release. If the proposed alternative to detention is accepted by the ID member, the member usually will order the release of the detainee on condition, and the released detainee must comply with the terms and conditions imposed on them. Otherwise, they may be taken into custody again. The detention review decisions made by the ID members can't be appealed to a higher tribunal of the IRB. If a party of the proceeding is of the opinion that the decision made by the ID member is wrong, they may seek judicial review at the federal court. For more information, please visit the IRB webpage, Detention Reviews, in the description below. That's all for today. Thank you for watching. We wish you a wonderful Canadian immigration journey and welcome you to reach out to us. Next time, we will explain the admissibility hearing and detention review in Mandarin. See you on July 4th.